Welcome to the deep dive. Today, we're not just covering a topic. We're really setting out on a mission of mastery. This deep dive is all about getting you, the listener, to an elite, professional level of understanding. We're tackling the rights of children framework, specifically, how it plays out in India.
It's incredibly complex, but absolutely critical.
Exactly. We've got some dense source material here, essential pediatric literature, constitutional stuff, detailed laws. And the goal isn't just, knowing the acronym.
Oh, not at all.
It's about understanding how it all works together. Global commitments, national laws, professional duties, how they actually intersect to protect children on the ground. We're aiming for real synthesis, context, practical application.
Yeah, the operational side is key.
The stakes here, legally, medically, socially, they just couldn't be higher. So to really master this, we need to unpack the philosophy behind the Constitution and follow that thread right through to the specific enforceable laws. Okay, let's unpack this.
That's a great way to put it. Look, the foundation for child rights in India rests on this really powerful kind of dual commitment. First, the Constitution guarantees equality for everyone, right?
Standard democratic principle.
Yes, but crucially, it goes further. It explicitly pledges special protection for children. That's not just rhetoric. It's a constitutional mandate, a specific carve-out.
Okay.
And then this national commitment got anchored internationally when India accepted the UN Convention on the Rights of the UNCRC back in 1992.
Right.
So our mission today, as you said, is to see how these big ideas, these global standards and national promises actually filter down. How do they become practical policy, actionable laws? And maybe most importantly for many listening, how do they translate into mandated duties for professionals, doctors, lawyers, social workers?
Understanding that whole chain of accountability.
Yes,
Okay, so that journey, that filtering down, it really starts with the global gold standard, the UNCRC. Looking at our sources, it's clear this wasn't just about suggesting a few tweaks. It seems to mandate some pretty deep structural shifts. Where do we see those shifts happening?
Well, they happen on two main levels, and they're interlocked. The first is, you could say, the macro level, policy and decision-making. This is where governments decide, where to put resources, how to set up institutions.
The high-level stuff.
Exactly. But the second level is arguably more transformative, especially for the professionals listening. It's the mandated change in practice, in direct service provision, particularly in healthcare, you see. The convention really pushes for a proactive approach to child health and well-being, not just reactive.
And what really stands out is the direct responsibility it seems to place on professionals, specifically mentioning the medical community. The sources say pediatricians must know child rights across these 5 key areas: survival, identity, development, protection, and participation. That feels like it pushes the doctor's role way beyond just clinical treatment.
Oh, absolutely. It fundamentally reframes the pediatric obligation. It's not just about diagnosis and cure anymore. They're expected to align their practice with advocacy efforts.
Advocacy, so lobbying, educating.
Yes, lobbying, educating, being primary advocates, recognizing that things like poverty, lack of education, or institutional failures, what we call the social determinants of health, are directly tied to a child's health outcome. Their job isn't just fixing sickness, it's protecting the very environment where health can actually thrive.
That's a significant shift in mindset.
It is.
So to really get that mastery we're aiming for, we need to internalize the specific UNCRC articles driving this. Let's maybe group them by theme, like the sources do, starting with protection. Seems fundamental.
Right. For protection, you've got Article 2 first. Non-discrimination. Sounds simple, but it means these rights apply to every child. No exceptions for background, disability, circumstances, anything.
Foundational.
Then there's Article 19, which is really comprehensive. It guarantees protection from all forms of violence: physical, mental abuse, neglect, negligent treatment. This basically requires the state to set up systems for prevention and response. We'll see this echoed later when we talk about the POCSO Act in India.
Okay, makes sense. Then survival and development.
Article 6 is the big one here, the fundamental right to survival and development. It's broad, but for the health sector, Article 24 is really the core mandate. That's the right to health and access to healthcare services.
Which implies more than just hospital access, right?
Much more. It covers prevention, nutrition, environmental health improvements, the whole spectrum needed for healthy development.
And there are related articles, too.
Yes, definitely. Article 23 is crucial. It ensures the rights of disabled children to special care and resources, focusing on dignity and participation. And Article 27 guarantees the right to an adequate standard of living. This links directly to how we define neglect later on, you see. It's about having the basics needed to thrive.
Got it. Okay. What about participation and identity? This feels like where the child is recognized as an individual, not just someone needing care.
Exactly right. And often, this is the area that gets overlooked in practice. Article 12 is key. The right to express views. It means institutions have to consider a child's opinion, factoring in their maturity when making decisions that affect them.
That's powerful.
It is. Then Article 14 covers freedom of thought, conscience, religion, and also the freedom to seek, receive, and share information. Article 31 might seem softer, but it's vital. Participation in leisure, recreation, play, that's essential for development.
Can't forget play.
Never.
Yeah.
And Article 30 confirms the right to practice one's own culture and religion, incredibly important in a diverse place like India.
And finally, the family context. But how does the UNCRC address that?
It places huge importance on the family environment. Article 3 is maybe the most cited. The best interests of the child must be the primary consideration in all actions concerning children. Doesn't matter if it's a public body or a private institution.
The guiding principle.
Absolutely. Article 9 deals with separation, ensuring a child maintains contact with parents unless it's harmful. And Article 18 mandates state assistance to parents with their child-rearing responsibilities. It recognizes that supporting parents is actually a public good, essential for child well-being.
So it's this really holistic 360-degree view.
That's the strength of the UNCRC. And importantly, these rights don't just exist in a vacuum. They're now deeply connected to the big global policy agenda for the 21st century. The Sustainable Development Goals, the SDGs, aiming for 2030.
Right, the SDGs. Adopted by the UN in September 2015. I remember the previous framework, the Millennium Development Goals, the MDGs. They got some criticism for being maybe a bit too narrow, right? Focused heavily on certain health metrics.
That's a fair assessment. The MDGs, set up back in 2000, did achieve things, especially around poverty and specific health outcomes like infant mortality. But the SDGs, with their 17 goals and 169 targets, are fundamentally different.
How so? What makes them transformative, as the sources say?
Well, two key things. First, they're universal. They apply to all countries, rich and poor alike. It's not just a developing world agenda. Second, they're incredibly integrated. They explicitly link environmental sustainability, economic growth, and social justice together.
Oh.
And they emphasize not just wiping out poverty, but actively fighting inequality. So for child rights, this means the SDG goals on nutrition, education, clean water, gender equality, decent work. They're all seen as interconnected pillars. You can't really achieve one without the others, and they all contribute to fulfilling a child's right to survival and development.
So the UNCRC gives the rights philosophy, the SDGs give the broad development targets. How did India build the actual machinery, the institutions, to put this into practice nationally?
India realized pretty early on that you needed a dedicated engine for this. A major move was upgrading the Ministry of Women and Child Development, the MWCD, to an independent ministry in 2006. That gave it more political weight, more focus.
Makes sense.
And right after that, in 2007, the National Commission for Protection of Child Rights, the NCPCR, was set up.
The NCPCR, that's the main watchdog, right? Does it just monitor? Or does it have teeth?
It definitely has teeth. It holds significant quasi-judicial powers. Its job is to promote and protect child rights, review the safeguards already in place under the Constitution and other laws, and crucially, when the NCPCR was established, it also mandated that states set up their own commissions.
Decentralization.
Exactly. It ensures that oversight and, importantly, grievance redressal isn't just stuck in Delhi. It can operate closer to where problems actually happen at the state level.
And it's not just government bodies involved in this oversight, is it?
Oh, absolutely not. The whole ecosystem relies heavily on NGOs, non-governmental organizations, community groups, and the media. They function as vital watchdogs, constantly monitoring, reporting, advocating. This multi-stakeholder vigilance is essential, especially given the sheer scale of India.
Okay, so we have the institutions. What about the guiding policy documents?
Okay.
The sources list quite a few. There's a layering of commitment here, starting with the National Charter for Children back in 2003.
Yes, the 2003 charter was interesting. It didn't just talk about the government's commitment. It uniquely listed out children's duties, too, towards family, society, the nation. A bit philosophical, maybe, but it sets a tone. Then came the National Policy for Children in 2013, which firmly adopted that rights-based approach we've been talking about. And the National Plan of Action for Children in 2016 really commits to creating that enabling environment for survival, growth, development, and protection.
And beyond these big overarching policies, there are some very specific ones targeting particular vulnerabilities.
Right. For example, the Policy Framework for Children and AIDS from 2007 was crucial. It aimed to integrate services for affected children into existing programs, tackling not just medical needs, but also the huge issue of social stigma. Then there's the National Policy for Persons with Disabilities from 2006, with specific provisions for children.
And one that really struck me, looking at the balance between development projects and child protection, was the National Rehabilitation and Resettlement Policy from 2007.
That one is incredibly important. It basically says that any project infrastructure, mining, industry that involves displacing families must first conduct a detailed social impact assessment.
Yeah.
And that assessment has to specifically look at the potential harm to the children involved, their lives, their education, their health. It forces governments and companies to really consider the human cost, especially on kids, before they even start digging. It internalizes that cost.
That's a powerful safeguard, in theory at least.
It is. And supporting that, you also have the National Urban Housing and Habitat Policy from 2007, which aims to ensure shelter and basic services at affordable prices, addressing that fundamental need for a safe, stable place to live.
Right. We've mapped out the broad policies, the institutions. Now we need to get into the specific laws, the legislative muscle that creates real accountability, defines offenses. This is where, the commitment moves from philosophy to actual enforcement.
Absolutely. And when you talk about enforcement and child protection in India, you have to start with POCSO, the Protection of Children from Sexual Offences Act, 2012.
POCSO. The sources call it the first comprehensive law on sexual abuse in India. Now, India had penal codes before, obviously. What was it about POCSO that made legal experts consider it so, groundbreaking?
It was a shift both in philosophy and, crucially, in procedure. Philosophically, it just cleared away ambiguity. It defined a child simply anyone under 18, explicitly included adolescents, and it made the victim's age the central factor, not their behavior or consent, which was a huge problem previously.
Okay. Clarity on who is a child.
Yes. And procedurally, it massively expanded the scope of offenses. It clearly defined different types: penetrative assault, non-penetrative assault, sexual harassment, even using children for pornography. That level of detail wasn't there before.
That clarity is one thing, but you mentioned procedure. How did POCSO change how things actually happen, say in police stations or courtrooms, to ensure the best interest and well-being of the child?
This is probably its most profound impact. POCSO essentially forced the entire legal and medical system to adapt to the child's psychological needs during the justice process.
How so?
It mandates things like child-friendly police procedures, special training for officers, judicial processes designed to minimize re-traumatization. For example, allowing a child to testify via video link, ensuring a female investigator is present, banning the repetitive questioning of the child, safeguarding the victim's identity throughout the investigation and trial.
So moving away from the often harsh adversarial system.
Exactly. Before POCSO, the system could feel like another assault. The act aimed to shift the focus towards, a more therapeutic form of justice, if you like, and another huge procedural change. POCSO made reporting of suspected abuse mandatory.
Mandatory for whom?
For everyone. Any citizen, any professional, any institution that suspects a crime under the act has a legal duty to report it. It creates a shared responsibility across society.
That's significant. And you mentioned earlier the definition of aggravated assault under POCSO. It's not just about the act itself, but who commits it. Why single out certain professions or roles?
It's all about the breach of trust. An assault becomes aggravated if the abuser is someone in a position of authority or care. Think police officers, army personnel, doctors, hospital staff, school staff.
People who we're supposed to protect.
Precisely. The law recognizes that the violation is far worse when the perpetrator exploits that position of power or trust or role where a child is meant to feel safe. It's also aggravated if the victim is mentally ill or physically disabled, acknowledging their increased vulnerability.
Okay. Moving on, another major piece of legislation was the Juvenile Justice Care and Protection of Children Act of 2015. This one generated a lot of debate, didn't it? Because it seemed to move away from the purely rehabilitative approach of the older law.
That's right. The GHAI Act 2015, which came into force in January 2016, still prioritizes rehabilitation for most minors. But it introduced a very controversial amendment.
Which was?
It allows juveniles, specifically those in the 16 to 18-year age group, who are accused of committing heinous offenses defined as crimes punishable by 7 years or more in prison, to potentially be tried as adults.
That's a massive philosophical shift. What was the thinking behind that? Taking away that blanket protection of childhood, even for serious crimes.
It stemmed from, frankly, intense public outcry after some particularly brutal crimes committed by older adolescents. The argument essentially became that for the most extreme, heinous acts, the need for deterrence and holding individuals accountable for really grave actions had to be balanced against the principle of protecting childhood.
A difficult balance.
Incredibly difficult. The Act tries to manage this by setting up a juvenile justice board. This board has to conduct a preliminary assessment, basically, trying to determine if the 16 to 18-year-old had the mental capacity and maturity to understand the consequences of the heinous crime they allegedly committed. Only after that assessment can they decide whether to transfer the case to an adult court.
So it's not automatic.
No, it's not automatic. It was an attempt to acknowledge that perhaps absolute blanket protection might, in very rare extreme cases, undermine public faith in justice. It's worth noting, though, that even if tried as an adult, the sentence still can't include the death penalty or life imprisonment without the possibility of release, so some protection remains.
Got it. And alongside these major acts, we shouldn't forget the other laws that sort of scaffold the whole rights framework, ensuring basic entitlements.
Absolutely. Key among those is the Right to Free and Compulsory Education Act from 2009, guaranteeing schooling for kids aged 6 to 14. You also have the Commissions for Protection of Child Rights Act of 2005, which is the law that actually established the NCPCR we talked about earlier. Then there's the Prohibition of Child Marriage Act from 2006, tackling a deep-rooted social issue. And importantly, the Child Labor Prohibition and Regulation Act of 1986. While it's an older law, it's been strengthened over time with notifications in 2006 and 2008 that expanded the list of hazardous occupations and processes banned for children. Though, as we'll discuss, tackling child labor remains incredibly complex because of poverty.
Okay, so that's a pretty extensive legislative toolkit.
Yep.
It provides the stick, if you like the rules, the consequences. But laws on paper don't automatically feed a child or deliver a vaccine, especially in a country the size of India. Implementation is the massive challenge, isn't it?
That's the crux of it. Legislation sets the framework, defines the rights and offenses, but you need the programs, the actual delivery mechanisms, to bridge the gap between law and reality. Without massive, dedicated social programs that actually reach people, especially in remote areas, the mandates often just remain on paper.
So let's look at those programs. The sources highlight the integrated services, first ICDS and ICPS. They seem like the big umbrella initiatives.
They are. Let's start with ICDS, the Integrated Child Development Services. This is a huge program running since 1975, one of the biggest of its kind globally. Think of ICDS as the physical network, the thousands upon thousands of Anganwadi centers you find in villages and urban slums.
The frontline delivery point.
Exactly. ICDS focuses on early childhood care, preschool education, non-formal, supplementary nutrition, basic health services like immunization, health checkups, referral services. It targets children under 6, plus pregnant women and nursing mothers. It's really the foundational platform for delivering essential services.
Okay, that's ICDS for general development. What about ICPS?
ICPS, the Integrated Child Protection Scheme, is newer and focuses specifically on the protection side. Its goal is to build that safe, protective environment for children who are in difficult circumstances. It works on prevention, reforming institutional care, like children's homes, non-institutional care, and rehabilitation. So while ICDS is about broad development, ICPS is about safeguarding, rescue, and recovery for vulnerable kids.
Makes sense. How do these two connect with basic health delivery?
Through other critical health and nutrition programs. The National Rural Health Mission, or NRHM, is key. It provides the health infrastructure in rural areas, which directly supports the health components of ICDS delivered at the Anganwadi.
Okay.
Then you have the Universal Immunization Program, a cornerstone of public health in IMNCI, the integrated management of neonatal and childhood illness. IMNCI provides standardized protocols for health workers at the community level to manage common childhood illnesses effectively. And we absolutely have to mention the midday meal scheme.
In schools?
Yes, primarily in government schools. It's massive and crucial, not just for nutrition, but also for education. It tackles hunger for older children and acts as a major incentive for parents to enroll and keep their kids, especially girls, in school. It directly links food security to educational access.
Right, that connection is vital.
Oh,
But shifting to education specifically for the 6 to 14 age group, the main program seems to be Sarva Shiksha Abhiyan, or SSA.
SSA is India's flagship program for achieving universal elementary education, mandated by the Right to Education Act. What makes it potentially powerful isn't just the funding, though that's huge. It's the emphasis on community involvement and decentralized local-level planning.
Trying to make it responsive to local needs.
Exactly. It actively tries to bridge those persistent gaps, social gaps like caste, gender gaps, regional disparities, to ensure that marginalized children, particularly those from scheduled castes, scheduled tribes, and minority communities, actually get enrolled and, just as importantly, stay in school.
And there's a specific program focused just on girls' education, too. Kasturba Gandhi Balika Vidyalaya.
Yes, the KGBB program. This sets up residential schools, mainly at the upper primary elementary level, specifically in areas identified as educationally backward blocks where girls' enrollment is particularly low.
Why residents?
It acknowledges that for adolescent girls in many communities, there are specific social barriers, safety concerns, or pressures for early marriage or domestic work that prevent them from continuing education. A residential school provides a protected, dedicated learning environment to overcome some of those barriers.
Understood. Okay, finally, let's talk about the lifelines, the programs designed for immediate help for kids in really acute distress.
This is the emergency response system, and the most critical one here is Childline. It's a national 24-hour toll-free number, 2098. Anyone can call it.
What does it do?
It provides immediate outreach and intervention for children in any kind of distress if they're abandoned, abused, lost, run away, living on the streets, need medical help, anything. It acts as the first responder, connecting the child directly to the statutory bodies like the police or, more often, the Child Welfare Committee, CWC, for proper care and protection. It's absolutely vital.
A crucial safety net.
Definitely. Then, for longer-term protection against specific dangers like trafficking, there's Ujjwala. This is a comprehensive scheme focused on prevention, rescue, rehabilitation, and crucially, reintegration of trafficking victims.
And what about using financial incentives? You mentioned Dhanalakshmi.
Yes, schemes like Dhanalakshmi are interesting because they use conditional cash transfers. Basically, they give money to families, usually linked to the girl child, if certain conditions are met, like enrolling her in school, ensuring she gets immunized, delaying marriage.
So using economics as a tool for protection.
Exactly. It tries to incentivize positive behaviors, especially in poor communities where economic pressures might otherwise lead to negative outcomes for girls, like dropping out of school or early marriage. It's an attempt to align economic incentives with child rights goals.
Okay, we've mapped the laws, the programs, the whole infrastructure. Now we have to confront the harsh reality that makes all this necessary: child abuse and neglect. For the professionals listening, achieving that mastery means knowing the precise definitions and, crucially, having a high index of suspicion based on specific indicators.
Absolutely. We have to start with the standard definition, which comes from the World Health Organization, the WHO. It defines child abuse or maltreatment pretty broadly: physical or emotional ill treatment, sexual abuse, neglect, negligent treatment, or commercial or other exploitation.
Okay.
That results in actual or potential harm to the child's health, survival, development, or dignity. That potential harm part is important.
But the source material makes a really critical point here. It says the definition used in the Indian context needs to be even broader than the standard WHO one. Why is that? Why the need for expansion?
It really reflects the specific systemic challenges you see in a vast developing country with significant poverty and inequality. The Indian context definition must explicitly include children who are deprived of basic necessities like education, early development opportunities, essential health care, or adequate nutrition.
So it's broadening neglect.
In a way, yes. It recognizes that systemic failure where the state or the family, even if resources might be available somewhere in the system, fails to provide these basic rights is itself a form of abuse or neglect. It harms development and dignity just as surely as direct violence might. It moves beyond just individual acts to include socioeconomic deprivation as a factor.
That's a profound point.
It is. And within this expanded view, the definition tragically identifies child labor and trafficking as the absolute worst kinds of child abuse. It recognizes the devastating, comprehensive, and often irreversible damage these inflict on a child's entire life.
Okay, let's dig into the four main categories of abuse. The sources detail, starting with the most obvious, perhaps: physical abuse.
Right. Physical abuse is defined as acts of commission, meaning something done to the child by a caregiver that causes actual or potential physical harm. It's important to distinguish this from genuine accidents. There's an element of intent or negligence leading to the harm.
Got it. A second.
Sexual abuse. This involved acts where a caregiver, or someone in a position of trust, uses a child for their own sexual gratification. This is where the POCSO Act provides the specific legal definitions and procedures.
Third category, emotional abuse. This sounds harder to pin down.
It often is. Emotional abuse is more about failures or acts that harm a child's psychological well-being. It includes failing to provide a supportive, nurturing environment, or specific acts like constant ridicule, terrorizing the child, isolating them, rejecting them, things that fundamentally damage their emotional health and development. It's insidious and often leaves no physical scars.
Difficult to prove, I imagine.
Very. And finally, the fourth category, neglect. We touched on this, but it carries a really critical distinction in practice. How is it defined, and how does a professional separate it from just poverty?
Okay, so neglect is the failure of a parent or guardian to provide for the child's basic developmental needs: health, education, emotional support, nutrition, shelter, safe living conditions. Now, here's the crucial distinction professionals must make, especially when considering mandatory reporting. Neglect is legally distinguished from the unavoidable consequences of poverty only when there's evidence that reasonable resources were actually available to the caregiver, and they deliberately failed to use them for the child's benefit.
Can you give an example?
Sure. Let's say a child is severely malnourished. If the family is eligible for and receives government food rations through ICDS, but the parents consistently fail to provide that food to the child, that might cross the line into neglect even if the family is poor overall, because a resource was available.
But if the family lives in extreme poverty, maybe in a remote area with no access to rations or health care, and the child is malnourished simply because there's no food and no resources, that's primarily an issue of poverty requiring social welfare intervention, not necessarily a case for punitive child protection action against the parents for neglect.
That's a vital distinction for anyone making a report.
Absolutely vital. It dictates the entire intervention pathway.
This brings us squarely to the clinical side. For doctors, nurses, health workers, what specific signs, what features or indicators should immediately raise that high index of suspicion we mentioned?
Okay, for severe physical abuse, tragically, if it's fatal, the cause is often non-accidental head trauma or severe injury to internal organs like the liver or spleen. Radiologically on x-rays, the classic sign is multiple fractures, often in different stages of healing.
Meaning injuries happen over time.
Exactly. Not from a single fall or accident. That pattern strongly suggests repeated abuse. And we have to emphasize shaken infant syndrome. This is caused by violently shaking a baby. The sources are stark. About a third of infants who are severely shaken die.
A third?
Yes. And those who survive often have devastating lifelong consequences. Severe mental retardation, cerebral palsy, blindness. Any suspicion of non-accidental head injury in an infant demands immediate, urgent action and reporting.
What about indicators for sexual abuse?
Yeah.
These might be less obvious physically sometimes.
Often, yes. Professionals need to be alert to a range of signs, both physical and behavioral. Physically, it could be things like unexplained genital soreness or injury, recurrent urinary tract infections without a clear medical cause, persistent abdominal pain, constipation. Behaviorally, red flags include sudden changes like withdrawal, anxiety, depression, aggression, sleep disturbances, or perhaps worryingly, age-inappropriate sexual knowledge or behavior.
So it requires real vigilance.
Extreme vigilance. And because secrecy is so common, it needs a high index of suspicion combined with a very supportive, non-judgmental approach to allow a child to feel safe enough to disclose if they can.
And finally, neglect. How does that typically manifest clinically?
Neglect often shows up as chronic problems. Persistent failure to thrive, the child just isn't growing properly. Consistent failure to seek basic health care, like missing routine immunizations or not getting treatment for common illnesses. Obvious deprivation of education or adequate nutrition, lack of supervision, poor hygiene, unsafe living conditions. These often prompt a professional not just to treat the symptom, but to investigate the cause and likely refer to the Child Welfare Committee, the CWC.
Recognizing and reporting is one part, but the bigger goal has to be prevention, right? Systemic change. How do the sources suggest we move towards reducing abuse on a larger scale?
The first step is framing child abuse as a major national social and public health problem. It needs the same level of policy attention and resources as, say, tackling a major disease epidemic. And strategies have to specifically focus on the most marginal of these groups: children in urban slums, kids living on the streets, children of migrant workers like those on construction sites. They often fall through the cracks of regular support systems.
What about the huge issue of child labor? The sources acknowledge abolition is hard due to poverty, so what's the recommended approach?
It's a pragmatic, if difficult, stance. While abolition is the ultimate aim, the immediate governmental responsibility, where child labor isn't completely banned by law for certain ages or tasks, is to ensure that working children are not exploited. That means guaranteeing they get some time for education, like part-time schooling, receive basic health care, and get adequate care and protection from their employer. It's about harm reduction and protecting fundamental rights, even within that difficult reality. Exploitation must always be prevented.
And how does this filter down to the local level, especially in rural areas? Is there a specific strategy?
Yes, the framework explicitly gives responsibility to the panchayats, the elected village councils. Panchayat officials are legally mandated to ensure that basic education, nutrition, healthcare, and sanitation are actually available and accessed by every child in their village. They are the first line of defense. They're supposed to make sure kids are in school, not doing hazardous work, and protected from harmful traditional practices or excessive family labor. It pushes responsibility right down to the community leaders.
Which brings us back full circle almost to the professional on the front line, particularly the pediatrician.
Absolutely. They're often the first ones to see the signs, the first point of contact, and therefore they have to be among the most informed and vocal advocates.
So summarizing their full mandate, considering all the laws like POCSO we've discussed.
Okay, their mandate is multifaceted. 1. Recognize the signs of abuse or neglect. 2. Provide appropriate medical care. 3. Formally report suspected cases to the correct authorities, police, CWC. 4. Crucially, they need to be sensitized on how to use the POCSO Act, effectively understanding police procedures, their role in providing medical evidence in a child-friendly manner, how to document injuries properly, while always protecting the child victim.
It's not just medical knowledge then, it's legal and procedural knowledge too.
Exactly. They need to know who to call for help, the Special Juvenile Police Units, SJPU, the Child Welfare Committees, CWC, Childline, 1098, and professional bodies like the Indian Academy of Pediatrics provide specific guidelines to help them navigate these complex clinical and ethical duties, always prioritizing the child's best interests and maintaining confidentiality appropriately.
Okay, moving from the really difficult topic of abuse and neglect, let's shift focus towards a crucial pathway for rehabilitation and providing stability for children who can't stay with their biological families. That's adoption. The sources frame this around the idea of a fundamental right to a family.
That framing is important. It emphasizes that putting a child in long-term institutional care should always be the absolute last resort. Adoption offers a chance for permanency, for a secure family environment, which is vital for development. But it's a process that's quite rightly very heavily regulated. It requires close coordination between medical, social work, and legal professionals.
So let's break down that legal framework. Who is the main authority overseeing adoption in India?
The nodal authority, the central body, is CARA, the Central Adoption Resource Authority. It functions as an autonomous body under the Ministry of Women and Child Development. ARA's role is essentially to be the main regulator and facilitator. It monitors and regulates all adoptions both within India, in-country, and adoptions of Indian children by families abroad, inter-country, to make sure everything is done legally, ethically, and transparently.
And a really key point the sources make is about who can actually place a child for adoption.
Yes, this is critical for professionals, especially in hospitals or clinics, to understand. Only specialized adoption agencies, SAAs, that are recognized and licensed by the state government are legally allowed to handle the placement of children for adoption.
So no direct placements by hospitals.
Absolutely not. Direct adoption arranged by hospitals, maternity homes, nursing homes, or individuals is strictly prohibited and illegal. It carries severe penalties. This rule is there primarily to prevent child trafficking and ensure that all adoptions go through proper legal checks and balances focused on the child's welfare.
Right. Now, there was a major social and legal shift regarding who could adopt, particularly after the Juvenile Justice Act of 2000 came into effect. Can you explain how that changed things?
Before 2000, the situation was quite fragmented legally. Hindus could adopt under their specific law, the Hindu Adoption and Maintenance Act, SHMA. But people from other religious communities often couldn't legally adopt in the full sense. They could usually only become legal guardians under the Guardianship and Wards Act, which doesn't confer the same full parental rights and inheritance status as adoption.
So different rules for different groups.
Exactly. The GHAI Act 2000 essentially created a uniform, secular, legal pathway for adoption that was open to all Indian citizens.
What did that mean in practice?
It meant that people of any religion could now legally adopt a minor child. It also opened adoption eligibility, significantly irrespective of the prospective parent's marital status, so single people could adopt. And it removed old restrictions based on the sex of the child being adopted or whether the adoptive parent already had biological children of the same sex. It really modernized and mainstreamed adoption as a legal way to form a family across all communities in India.
Okay, let's walk through the actual procedures. For a child who might be relinquished by parents or found abandoned, what's the very first crucial legal step before they can even be considered for adoption?
The first port of call is always the Child Welfare Committee, the CWC. CWC has the sole legal authority to declare a child legally free for adoption.
How does that work for, say, an abandoned child?
If a child is found abandoned, they must be produced before the CWC. The CWC then conducts an inquiry, tries to trace the biological parents, often through police reports, public notices. If, after a stipulated period, no one comes forward or can be found, the CWC will formally declare the child destitute and legally free for adoption placement through a licensed agency.
And what if parents want to voluntarily relinquish their child?
That also has a strict procedure. The biological parents must execute a formal deed of surrender before the CWC. This document usually needs to be witnessed, perhaps by a hospital authority if the surrender happens soon after birth, or a relative. And importantly, the law mandates a 2-month reconsideration period after signing the deed.
The cooling off period.
Exactly. It gives the biological parents a chance to change their mind before the relinquishment becomes final and the CWC declares the child legally free. It's a safeguard to ensure the decision isn't made under duress or temporary crisis.
Right. Now, what about the prospective adopted parents? What process do they have to go through?
Well, eligibility criteria exist regarding age, health, financial stability, marital status, though single parents are eligible. They must approach a CRA-registered licensed adoption agency in their area. The process they undergo is quite intensive, as it should be.
What does it involve?
It involves mandatory pre-adoption counseling sessions to prepare them. A detailed home study report is conducted by a professional social worker. This involves visits to their home, interviews, assessment of their background, motivation, capacity to parent. They also need to submit various documents, proof of identity, income, health certificates, marriage certificate, if applicable. The whole process is designed to ensure the child is placed in a safe, nurturing, and suitable environment.
And for parents wanting to adopt from India but living overseas inter-country adoption?
That process is even more regulated, involving coordination between countries. Prospective adoptive parents abroad must work through an adoption agency that's authorized or accredited in their own country. That foreign agency forwards the application to a recognized Indian placement agency, and the whole process is overseen by PHI-RA. There are often post-placement follow-up reports required for several years after the child joins the family until the adoption is legally finalized in the parent's home country.
Given all these checks and balances, legal, social modalities, the pediatricians seem to have a really critical and potentially quite sensitive role in the adoption journey. It sounds like it goes way beyond just a quick health check.
Oh, absolutely. The pediatrician's role is multifaceted and ethically quite demanding here. Firstly, they often act as counselors.
Counseling whom?
Both sides, potentially. They should counsel biological parents considering relinquishment about the correct, safe, legal procedures, strongly discouraging dangerous or illegal abandonment or private arrangements. And they counsel prospective adoptive parents, helping them understand the process, potential health issues, and the emotional journey involved.
And the medical evaluation itself, what are the key responsibilities there?
The medical evaluation of the child being placed is crucial. The pediatrician needs to conduct a thorough examination. They have an ethical duty to provide a realistic diagnosis and, importantly, a realistic prognosis to the prospective adoptive parents. This requires balancing honesty about any health conditions or developmental risks with a supportive attitude. It's a real tightrope walk.
And there's a specific requirement about testing.
Yes, this is non-negotiable. Because of the window period for detecting certain infectious diseases like HIV or hepatitis B, the pediatrician must ensure that all essential screening tests are repeated after an appropriate interval, usually 3 to 6 months after the initial tests, before the adoption placement is legally finalized by the courts. This retesting is a critical safety measure for the child and the adoptive family.
So confirm negative status after the window period closes.
Precisely. And throughout this whole process, the pediatrician needs to maintain strict confidentiality about the child's biological background while offering ongoing support and reassurance to help the adoptive parents navigate any fears or challenges. So, looking back at this deep dive, I think we've managed to cover a huge amount of ground, hopefully achieving that sense of mastery we aimed for. We've gone from the highest levels of international law, the principles of the UNCRC, the broad goals of the SDGs, right down through India's specific legislative framework, focusing on key acts like POCSO and the GHAI Act. We've examined the crucial implementation programs like ICDS and ICPS, the health initiatives, the educational drives, and we've looked at the specific roles and responsibilities of NGOs, of local panchayats, of law enforcement, and critically, of medical professionals, especially in recognizing abuse and facilitating safe adoption through RA.
Yeah, it's a complex web, but the connections are clear.
They are, and I think the core insight that emerges from all this material remains starkly clear. The way a society treats its children, the status and well-being it affords them, is probably the most honest and unforgiving indicator of its overall commitment to human rights.
So what does this all mean? Where does this leave us?
Well, it means, hopefully, that you, our listener, now possess the detailed, professional-level knowledge needed to understand not just what the laws and policies are, but how they are supposed to function in the real world, the intent behind them.
Okay, so given everything we've just unpacked, this incredibly comprehensive legislative structure, the established programs, things like mandatory reporting being legally required for everyone under POCSO, the defined legal lines between neglect and poverty, the specific duties laid on local panchayat officials in villages, given all that exists on paper. Here's the final provocative thought we want to leave you with. How do we, as informed citizens, as professionals working within this system, most effectively bridge the gap? How do we transition from having arguably excellent legislation and established programs on the books to achieving absolute consistent enforcement on the ground? Enforcement that genuinely protects the most vulnerable, most marginalized children from exploitation and harm day in and day out. The question maybe is no longer primarily about the laws themselves, but about the collective will and action to make them truly real for every child.
That is indeed the critical challenge, something for all of us to think about long after this discussion ends. Thank you for joining us for this deep dive.